Harassment occurs when the employer or one of the workers engages in unwanted conduct, which is based on a worker's actual or perceived sexual orientation, and which has as its purpose or its effect either violating the person's dignity or creating an intimidating, hostile, degrading, humiliating, or even an offensive environment for the person. And whether or not any form of behaviour will be considered to be harassment will depend on the circumstances of the case, including the perception of the person who's on the receiving end. The kinds of things that fall under the concept of harassment could include a particularly offensive one-off jest, for example. But a one-off jest may well not be harassment, for example, because nobody actually realises that it is offensive in itself. Depending on the content of it, some will obviously be offensive. But harassment's going to cover things like bullying, name-calling. It'll cover things like teasing, and it doesn't necessarily have to be targeted at an individual. It could be just that there are homophobic jokes told around the office. Harassment can be intentional. Bullying, for example, is going to be intentional. It could be an intentional and malicious telling of a homophobic joke, deliberately to hurt somebody. But it'll also cover the situation where unintentionally homophobic language has been used, in fact without any malicious intent, but the office culture is just, it's become so ingrained in the office culture. It's going to cover also things like sexual advances, so sexual behaviour at work may amount to harassment in itself if it fulfills the criteria. And it'll also include the deliberate outing of somebody who doesn't want to be outed. Protection against harassment will extend to certain situations outside work. For example, the office party, harassment that occurs then will almost certainly be covered. On the other hand, it probably won't protect you if you happen to be at the local supermarket and one of your work colleagues comes up to you and is insulting or abusive on grounds of sexuality. Having said that, of course, that kind of behaviour is going to be very good evidence of behaviour at work. If, for example, the harassment is a known risk, so your employer hires in a comedian well known for homophobic humour, then there's an argument that you should have been protected from that harassment, and by their omissions, by their failure to protect you from that kind of harassment, in fact they're fed into that harassment. This gives rise to the question of whether the employer has to protect you from a foreseeable risk of harassment. And some legal commentators think that the answer is yes, others think no. What can be said is that in certain situations you'll be protected by health and safety provisions, but I stress again, this is a complex area of law, and it's exactly the kind of situation in which you need to go and seek professional legal advice. An example of harassment, a classic example of harassment, would be the, say, lesbian teacher who's working in a school environment. Somehow or other, the children in the school become aware of her sexual orientation, and she's subjected to abusive language about being a lesbian. Details of sexual practices are spoken about, graffiti goes up, and all of that. She's obviously being subjected to harassment by people other than her employer, and the question is, will she be protected under this new harassment provision? Well, the answer is that she should be, and this is supposed to be a piece of socially protective legislation. My own opinion is that the underlying European law will probably help to achieve the result that she wants, which is protection under the regulations in that instance. Victimisation means that you're treated less favourably than others who are in the same circumstances as you because you've done what's called a protected act. Now, a protected act means either making a complaint at work or intending to make a complaint at work about sexual orientation, discrimination or harassment. There's no particular formality about the concept of making a complaint about sexual orientation, discrimination at work. What has to be clear from the complaint is that you're complaining about treatment which is based on sexual orientation, and the employer punishes you in some way for making that complaint. And in those circumstances you can bring a complaint for victimisation. So the most straightforward example, I guess, would be someone who is denied promotion because they gave evidence at the tribunal of a colleague who brought a sexual orientation complaint against the organisation. An important point to remember about victimisation is that it doesn't actually matter whether the original complaint was successful itself or not. What does matter is whether the original complaint was made in good faith or not. If it wasn't made in good faith, you won't be protected against victimisation.